Welcome back, guys, to part 3 of this series, which looks at how to make an effective police complaint within the meaning of the Police Conduct Regulations 2020. In part 1 of the series, we looked at the uneven landscape of police complaints and the pros and cons in an otherwise biased system. In part 2, we look at the legitimacy of making a civil claim against the police, and in this final third part of natural justice, we look at how to go about making the complaint on police conduct to best effect. In the making of this short presentation for the layperson, we hope we have succeeded in providing a grounding in terminology and process by way of the learning objectives listed, some of which are covered in all 4 parts of this series on the landscape of police conduct and behaviour. So guys, let's make a start. Who is the AA? Well, sadly, the AA, or appropriate authority, will be the police force you are complaining about, specifically the PSD or Professional Standards Department. I would urge you to read some of the published findings on the PSD websites to become familiar with the game. Before we journey down the bumpy and uneven road of the landscape of police conduct, it might be befitting to begin at the end. And despite being a complex process, the outcomes are straightforward. The rest is dependent on the severity of your complaint and attention to detail in the making of it. The ultimate goal, if your complaint be so egregious, is the dismissal of the police officer for gross misconduct. The consequence of dismissal by gross misconduct for an officer is clear. He or she will be placed on a barred list held by the College of Policing and will be unable to work for any police force in the United Kingdom. Rest assured, with ailing police numbers, the spectrum will be skewed by the AA towards reflective practice, so it is important, if your conduct complaint is so egregious, to identify its severity and provide as much evidence to support it as you can. Okay, so you are driven and motivated to obtain justice. How different the circumstances may have been for the Mackeson case if groupthink and conduct had been more professional. Before we look at the system and outline, here is some advice in preparing your case. You may take a different view or take a different route. I won't read the slides verbatim, but will make comments around the points within them. Be meticulous in gathering evidence. In this respect, the Data Protection Act is your friend. Place requests rapidly and precisely for all that will assist you in creating an evidence bundle. That can include body-worn video, detention interview recordings, custody records, property searches. Do so before any officers attempt to interfere or obstruct material. That is not uncommon. Remember also that body-worn video is in the control of the officer offending. It is not secure or not forensic, and it can be manipulated, curtailed or obstructed. Rights of access teams are often nothing more than admin teams with little or no training or knowledge on DPA, other than the use of redaction software. State formally all requests are to be provided as hard copies or letters and not via online portals which only retain content for a limited period. Always obtain permanent records. In the majority of cases, your complaint may centre around legitimacy, i.e. whether a police officer applied the correct law in the right manner. If he has not, then his actions may not be lawful. It is therefore important to seek correct professional advice from solicitors or legals experienced in actions against the police. Legitimacy also requires, even if an officer uses the correct legislation, a justification for his action. For example, he must justify arrest on the basis of reason and necessity, both being required together. Otherwise, a wrongful arrest may ensue. Auditors are familiar with the common errors made by police officers ignorant of the law. For example, Section 50 of the Police and Anti-Social Behaviour Act and Section 43 of the Prevention of Terrorism Act. So keep an eye out on the channel for these other mainstay videos which should appear in the near future. Decide clearly the components of your complaint and where they sit in relation to the severity of the officer's action, in relation to the necessary bar required of severity, as will follow later in the slides. Assemble your evidence around those components, ready to make written representation by way of complaint. Before moving into mainstay conduct procedures, 2 footnotes are put in place for auditors. It is unclear whether intelligence gathering in some forces could potentially be being used to put in place malicious attempts in non-crime recording. If you want to check the PNC, then make free of charge a subject access request to view any record held on the police national computer. ACRO are the data processor or agency responsible for maintaining records provided to them from throughout the country. ACRO are generally very helpful. Their address is given in the link beneath the video. Just to conclude, here are a few examples of scenarios which bring into scope officers' honesty and integrity, even when banged to rights with their own body-worn video. In the first scenario, here we see an officer conducting an unlawful search or seizure without legal authority. Despite being told the same, the officer then went on to provide body-worn video without audio. Fortunately, his colleague's audio was audible. In the following incident, we illustrate by way of the diagrams to follow how officers masked a critical incident by obstructing and kettling in relation to the unlawful seizure of an item, ironically on the making of a conduct complaint. From the onset positions in the first slide, we see how movement and kettling obstructs a critical incident of an unlawful seizure. A stands in front of C's body-worn camera, obscuring the field of view. B, the offending officer, comes behind A's camera where an unlawful seizure takes place, meaning the only body-worn video that is effectively active is the offending officer B. The offending officer then provides that footage post-incident only in part. In this scenario, this brings into scope the honesty and integrity of the officers, disguising the unlawful seizure. Okay, let's delve into misconduct proper. The following slide, given by HMI, His Majesty's Inspectorate of Policing in 23, reflects public concern on the suitability of officers arising out of uplift. the massive national recruitment drives across UK forces. I have included the following slides from the 2014 College of Policing PDF, which was well written and clear and aimed at police officers. I won't read the slides verbatim, as you may stop and view the content at any point. You should also note that the context of the Code of Ethics changed in 2023, particularly for chief officers, and is outside the scope of this mainstay. However, the relevance to the Police Code of Conduct, the statutory instrument 2020, still remains. Not all standards of behaviour are sufficient to take a complaint to a police conduct hearing. That bar, relating to severity, is noted in the orange slide that follows. It soon becomes apparent that each conduct case and its severity and complexity is unique to individual circumstances. But I hear you ask, how can a packet of Jaffa cakes cause an officer to be dismissed for gross misconduct? The links are in the description, and I'll leave you to marvel on that one. The overriding factors would be that considered by the conduct panel at hearing, and that directed by the LQC, or the legally qualified chair, in the light of relevant precedent, notably that of Lord Justice Popplewell. So, as we can see, the rationale in assessing severity and applying sanctions is critical in the overall finding of a conduct hearing outcome. Identifying culpability, harm and aggravating factors within your complaint will therefore not be detrimental. So typically, in regard to culpability, did a senior rank give an order or instruction to the officer, or did the officer act of his own accord without making the necessary justification? Aggravating factors tend to lend to a higher culpability. Mitigating factors, on the other hand, reduce culpability. So, for example, did an officer refuse to do something he should have done? For example, check legislation when he told he was acting unlawfully? Or, in fact, whether the officer may have had previous written warnings. Just a little aside for the purposes of completeness. The police complaint system evolved from precedent around the conduct of professionals, notably solicitors or doctors. The conduct panel will have a variety of well-worn precedent to support their decision-making, much of which can be sourced in the College of Policing document on outcomes, the links of which are given beneath the video. Here are a few slides for your interest. If you're an auditor and have a big following, do not underplay the public trust and confidence, as this also is a significant factor that must be taken into consideration in any balancing test, and the dictum that justice must be seen to be done holds true. In my opinion, much of the, quotes, system is both reactive and sensitive to public perception, as can be seen from the Everett, Cousins and Mackeson cases. So, what happens if the complaint does not meet the threshold bar for severity for conduct hearing? Then the complaint will be dealt with as a service complaint by way of local resolution, and you will receive a standard outcome letter and an apology, as shown in the slides that follow. You still retain the right to appeal and may refuse to accept the apology. This will likely mean that the threshold of severity at some point will be reassessed. Let us look at West Yorkshire Police Professional Standards Department as a force example. There is clear and disproportionate outcome from West Yorkshire Police PSD, which can only amount to bias in the way complaints are processed and handled, ranging from no lines of communication to null responses to queries. Case handlers are often uninformed and irrational in their outcomes. There are certainly some very concerning responses. For example, PSD claim they cannot comment on the legitimacy of an officer's action, which would mean that they would fail in making any reasonable and accurate severity assessment. Okay, so let's return to the Code of Ethics 2014 in its entirety, as we have got a little sidelined in illustrating the severity of the complaint and local resolution. These slides are from the College of Policing 2014 Code of Ethics aimed at police officers and are a PDF which was available at the time. Email me as per email in description if you would like a copy of that. The relevance of some of these elements of the Code of Ethics must also be considered within the context and substance of the complaint. The evidential importance of these components should not at all be downplayed, as they may provide substantial support to the severity component of your complaint. Because of the scope of this particular mainstay, I am going to very, very quickly touch on some of the relevant scenarios relative to these elements of the Code of Ethics, as you can see from the slides in the video. Or you may request a copy of the PDF and read it in full in relation to the Code of Ethics. So far, we have illustrated the importance of honesty and integrity and duties and responsibility in relation to severity, they being the two major components, and we have illustrated that in the case of the Jaffa cake man. So we will now turn to other areas within the code, such as orders and instructions. Consider the scenario. A member of the public, in accordance with Home Office regulations and the College of Policing's Code of Ethics, are permitted as a member of the public to make a complaint in person to a sergeant or duty inspector on the conduct of a police officer at a designated police station in person, i.e. an operational station with a public help desk authorised by the Chief Constable. This brings into scope that of an inspector given orders and instructions to, quote, kick that person out. There is no effective definition of a lawful order or instruction, but it is worth noting the Police Federation's definition of what they interpret it to be. Could we be looking at the onset of attempting to pervert the course of justice? Consider this scenario in the context of equality and diversity. A traffic offender perpetrating traffic offences makes a malicious allegation of harassment against parties reporting the offences occurring in the public domain by the taking and making of images in a public place. The reporting persons were arrested, and during the process an unlawful search and seizure occurred where the computers and cameras were unlawfully seized without warrant, contrary to Section 2B of the Protection of Harassment Act 1997. In other words, the officers got legitimacy wrong and were acting unlawfully. This brings into scope, aside from acting without lawful authority, infringements on ACRO 10, which is the freedom of expression to take and make an image in the public domain, and ACRO 9, the right of privacy in one's own home. Okay, one final scenario before we touch on appeals and relevant review bodies. A police officer in a public foyer bellers out, "We have got all the logs, we have read them, we know you are a serial complainant." In effect, the police officer failed to note the logs were not merged, not managed, and were an administrative nightmare being opened and closed. The critical point here is that the police officer breached confidentiality under the Data Protection Act, disclosing to anyone else in the foyer what the nature and concern was in relation to the logs. Assuming your complaint has satisfied the severity criteria and those characteristics set out in Schedule 2 of the Police Conduct Regulations 2020 in relation to conduct, and that all relevant notices are set in place, then a conduct hearing will ensue. Let us qualify and identify the mechanics of the conduct hearing, which will usually occur at a PSD at a force headquarters. The conduct hearing panel, as described, contain appointees made from a selection list held by the PCC, the Police Crime Commissioner, the local body. The panel will consist of an independent lay panel member, a legally qualified chair or LQC, and a police officer from the appropriate authority in question, usually at the rank of superintendent or above. Forthcoming hearings and police appeal tribunals are published on the PSD pages, and the Police Reform Act also require the findings of a police conduct hearing to be published for a minimum of 28 days. A link is given beneath the video on how some forces select and appoint the independent and legally qualified chairs. There are circumstances when the appropriate authority may, as part of best practice on conditional criteria, self-refer, or on mandatory criteria, refer to the office of the IOPC. Those circumstances in relation to the latter are namely DSI, which means deaths or serious injuries. However, there are other conditional criteria which may lead to referral to the IOPC as the relevant review body. As a matter of opinion, the IOPC investigatory standards are likely good, but as per Trustpilot reviews, they are significantly let down by front-end admin teams, acting in many cases beyond their role. As you will now be realising, the first slide that appears identifies the key actors in the landscape of police conduct, namely the appropriate authority or PSD, the Police Crime Commissioner's Office and the IOPC. We turn our attention to appeals, or perhaps more precisely, review and the constraints and restrictions placed around it. The ethos of the system on police complaints should accord to the principles of natural justice, but there was a significant legislative change around 2020 that altered the landscape of police conduct and limits your scope as a complainant to a review based on what should be a reasonable and proportionate outcome on the basis of actions. These authorities, whether they be the relevant review bodies, will be unable to re-investigate the complaint. It is my opinion that that tends to fly in the face of natural justice, where the facts should be examined at all stages. So, in order to complete a thorough overview, we are going to look at the routes of review and appeal when outcomes are arrived at. Even if you have proven your case to be so egregious, such as to merit dismissal, a police officer still has a right of appeal at a police appeals tribunal, which are governed under the Police Appeal Tribunal Rules 2020. During that process, an officer may have substantial legal representation. The grounds for putting forward an appeal to tribunal are as given in the slides that follow. Okay guys, so that concludes the overview to making a police conduct complaint within the meaning of the Police Conduct Regulations. We may well make a fourth in the series in relation to appeals and reviews to conduct complaints. If you found this video interesting, please like, share and subscribe and help get the channel off the ground. Don't forget there are also some selected links beneath the video to which will help your understanding. Remember also, providing an outcome to a police misconduct complaint will also assist your heads of claim in any civil challenge. So don't forget, guys, please like and subscribe, and we'll see you on the next video.